Welcome to the second panel of our day. I'm Professor Alexandra Nadapov. I teach criminal law and criminal procedure here at Harvard. Before I was a law professor, I was an assistant federal public defender in Baltimore. And gun cases were, of course, the bread and butter of that work. And I had a young client early in my career who was facing a felon in possession federal charge, and he was a very talented, smart young guy. He was studying accounting at the local community college. His professors said glowing things about his prospects, and so we were at the jail where he was detained, and we had to meet in the broom closet because BCDC, the Baltimore City Detention Center, was such a hellhole that there were no rooms where you could have a privileged conversation, so we had to have the conversation in the broom closet. And we were talking about his case, and we were talking about his life. And he explained to me that he felt that in his neighborhood, he had to carry a gun because if he was perceived to be unarmed, then he would be a target, he would be a mark. And so he felt that just to go home, he really had no choice about this. And I said, well, then you're gonna have an ongoing big problem because this is your first federal charge, and we might be able to negotiate it down to probation or a lower sentence. But when you go home and if they catch you again, the way the federal sentencing guidelines work, you are going to be looking at a much, much longer sentence. And he said, how long? And so we sat there in the broom closet and worked out his sentencing guideline calculation for his next gun case, not the one he was currently charging, but the one that we both knew that he was at extremely high risk of incurring because he was, as it were, trapped between the Scylla and Charybdis of the violence in his own neighborhood and then Baltimore's over-policing of Black men. And I share that story because I think it captures something that helps me make sense of this conversation, which is that the gun challenge mirrors what we think of as a central challenge of criminal law itself, which is the twin problem of over and under enforcement. So we know, of course, that the criminal system famously underprotects Black people and Black communities from crime and from violence, even as it over-enforces and over-polices the criminal law against those same people and the same communities. And likewise, we underprotect Black people and Black communities from gun violence, and we over-enforce and discriminatorily enforce gun laws against those very same individuals and communities. And so I've always thought of over and under enforcement as sort of twin symptoms of the same disease, the same dysfunction, which are the subjects of the panels today. They are a symptom of inequality, racial inequality. They're a symptom of democratic dysfunction. They're a symptom of the political system's inability to or decision not to respond to the full panoply of needs and demands and rights of vulnerable populations. So this couldn't be a more important conversation. Very pleased to be here. We have a great panel today. Professor Huck, I don't think you can see me looking at you, but I am now looking at you or your profile picture on the screen. Aziz Huck is the Frank and Bernice Greenberg Professor of Law at the University of Chicago. He's a constitutional law scholar, an expert in civil liberties. His two most recent books are The Collapse of Constitutional Remedies and How to Save a Constitutional Democracy. Eric Rubin, here physically with us, is Assistant Professor of Law at the SMU Dedham School of Law. He's written extensively on the relationship between self-defense and the Second Amendment. He's a former fellow from the Brennan Center and a former criminal defense attorney. Adam Winkler is a professor at UCLA Law School, where he teaches and writes about constitutional law and has long had a special focus on guns and gun control. Among many other books, he is the author of Gunfight, The Battle Over the Right to Bear Arms in America. I think the norm here is each of our panelists will speak for about 10, 15 minutes. Professor Huck, I'm going to ask you to go first since you are dominating the room. So we'll let you start, and then we'll go in alphabetical order, and then we'll open it up to discussion amongst the panelists and our Q&A. Please, I will remind you as your last moderator did to please use the microphone so that everyone here can hear you, but also so the recording can pick up your question. Professor Huck.
Thanks so much, Professor Nadapov. I really appreciate the introduction, and I appreciate the work that's gone in by Jake, Joseph, Darrell, and others to putting this conference together. I apologize that I'm not there in person. I have an unvaccinated child in my bubble, and I'm not traveling as a consequence of that. Can I ask who I was running the Zoom on that end to enable screen sharing because it's been disabled on my end? And then you don't have to look at me, I have slides. So I'll put the slides up, but that requires me to be made a co-host. Maybe while that's happening.
They're working on it right now.
All right, if you can let me know when it happens. I'll start, although actually the slides are helpful at the beginning of my presentation. So this is the essay here is part of an ongoing project with a colleague of mine at the sociology department here at the University of Chicago, Robert Vargas. Thank you very much for making me the co-host. I appreciate that. I'm gonna open up my. I'm gonna take a second. Sorry about this. To open up a slide deck, which means you won't have to look at me, or won't have to look at me quite so much. Okay, great. So this is a joint project with a professor in sociology here at the University of Chicago, Robert Vargas, and the paper is written with one of his postgraduate assistants, Caitlin Loftus, who's been really important and done wonderful work, both in unearthing some of the historical material in the piece and then helping put together some of the empirics. And the larger project here that Professor Vargas and I are engaged in is thinking about the reasons for which the social movement that we saw and many of us participated in 2020 around Black Lives Matter has either prevailed in some respects or floundered in other respects. But the essay here takes that project, applies it to the, or identifies an intersection with the problem of guns that is the focus of this symposium. So in May 2020, Chicago, like many American cities, saw a wave of protests against police violence under the BLM banner. On one count, some 52,000 people, and I should confess, including myself, participated in BLM protests in the city of Chicago. Yet, a year later, the Chicago City Council passed Mayor Lori Lightfoot's municipal budget that included a $189 million increase in the police budget for the following year. More strikingly, Mayor Lightfoot's budget obtained support from several of the Democratic Socialist aldermen. One of them is seen here with a famous Vermont fashion icon, who had previously been BLM's most active supporters. So what happened to diffuse the force or the momentum of social change in Chicago? Unlike many other cities, Chicago does not have what Tony O'Rourke and his colleagues in a brilliant piece describe as structural entrenchment of law enforcement through state law. Quite to the contrary, in 2021, Governor Jay Pritzker of Illinois signed a sweeping criminal reform bill, partly in response to the BLM movement. So what happened in the city of Chicago? The answer our essay tries to show has in part to do with guns, and in particular in the way that we talk about guns. Chicago's mayor and its police chief legitimated an increase in policing, one that widened racial inequalities at a time of unprecedented pressure from BLM activists, by invoking a historically credentialed rhetoric of illegal guns and heightened enforcement of gun enforcement laws. Mayor Lightfoot deployed arguments about gun violence against her liberal, reform-minded political competitors. And the result of that has been a shift in policing resources that has increased the disparate burden of policing upon Chicago's Black and Hispanic communities without much evidence of an offsetting public safety benefit. One of the important pieces that we take up in the article, in the essay, is how this dynamic echoes political rhythms that Chicago has experienced many times before. Let me start with that history, and then I'll move into the present day explanation that the essay offers. Gun talk has played a central role in Chicago politics for more than 50 years. During and around crime waves in the 1960s, the 1980s, and the 2010s, both the mayor and other local elected and unelected officials have identified guns as the central axis of the crime problem. While regulatory and policing programs alike have been floated, the former regulatory programs have generally foundered, while the latter policing programs have endured. At the same time, gun rhetoric has played a specific role in countering social movements for reform. We play this through with respect to the first daily, the second daily, and the Emanuel administration, but let me give you just one example here in the presentation, which is the 1990s administration of Richard M. Daley. Daley II explained crime by a simple fact, quote, "We have too many guns." His response initially comprised a citywide assault weapon ban and an anti-loitering law that targeted gang members. Daley also turned his sights against gun makers. He filed a suit against several gun manufacturers in Illinois state court, citing a public nuisance theory. And he lobbied nationally against legislative immunity for those firms. Chicago's anti-loitering law would lead to more than 89,000 dispersion orders and more than 42,000 arrests in its first 3 years. It was invalidated in 1999 on Baker's grounds by the US Supreme Court, but would be reinstated in a slightly modified form. Meanwhile, the Illinois Supreme Court would eventually reject Daley's public nuisance suit against gun manufacturers, and his semi-automatic ban and the idea of a private right of action against gun makers would ultimately be dropped. Instead, in 1994, Daley worked hand in glove with Republican Illinois Governor Jim Edgar on a hardline crime bill that expanded juvenile detention, extended the death penalty, and imposed new and greater sanctions upon the unlawful sale or possession of handguns. The outcomes of Daley's political mobilization around guns, in short, was bifurcated. Regulatory measures targeting firearms supply tended to fall by the wayside. Meanwhile, coercive measures designed to expand the footprint of policing and to enlarge the punitive consequences of gun-related activity went through and survived legal and constitutional challenges. Now, flash forward to the end of the 2010s. By the August, the end of the summer of 2020, there had been 510 murders in my city. This was up from 262 in the same period in 2014. And in the first 8 months of 2021, there were 526 murders. Like earlier mayors, Lori Lightfoot faced simultaneous public pressure to change Chicago policing and to dramatically reduce crime. And like earlier mayors, Lightfoot's response to this dilemma has been to take gun crime as the axial problem in crime control. Again, she's proposed regulation that's floundered, but made tangible shifts in policing that has had racially disparate effects. Last year, Mayor Lightfoot declared at a press conference that we, quote, have a common enemy. It's the guns and her gangs. Likewise, her September 2020 comprehensive plan to reduce violence in Chicago starts by identifying the higher presence of guns and gun violence as the cause of Chicago's astronomical murder rate. That plan called for resources to be concentrated in 15 Chicago communities, places like Pullman, that have experienced high rates of gun violence. The proposed resources include street outreach, trauma-informed victim services, youth-designated programs, more re-entry and support services. The same comprehensive plan says nothing about increased police activity and nothing about increased police funding. So what happened? A year after that plan was published, many of the neighborhoods identified in it as needing funding, such as West Pullman on the south side of the city, have received none. While there have been some expenditures made under the plan, close observers suggest that most of the money that has been spent has gone to establish outreach groups, while overlooking jobs and education programs. Even as the Lightfoot administration's investment in communities has waned, its reliance upon policing has waxed. After being confirmed as the Chicago Police Department superintendent in April 2020, David Brown started reorganizing the police force to increase the number of gun seizures and illegal possession arrests. Brown, in particular, created a citywide unit that's tasked with responding to crime hotspots. And he has consistently, in his public statements, emphasized the number of guns that are confiscated by police. So what's been the effect of this increase in policing activity? Let me show you a couple of charts that lay this out. So the first chart draws upon the CPD's own data to show the number of firearms seizures occurring every year. And what you can see between 2019 and 2020 is that the sheer number of firearm seizures jumps from 19 to 20. Right? So, although if you read the main Chicago papers, the Sun-Times or the Tribune, you will see a number of stories about the slowdown in policing that accompanied the BLM movement in the summer of 2020. What we see here is an increase, and a substantial one, in one particular parameter of that activity, the number of gun seizures. So what's happening? How is that occurring? This is a chart drawn from data that the state of Illinois mandates collection of the rates of traffic and pedestrian stops over time. We go back to 2016 here. So the reason we go back to 2016 is that the rate of pedestrian stops, which is the filled-in line rather than the dotted line, was much higher in 2015 and drops to about a quarter or a fifth in 2016. Right? This is associated with chilling of police activity that follows the release of the Laquan McDonald video at the end of the year. Right? So if we were to extend the line back, with the pedestrian line would go up sharply, which would, I think, confuse the point that we are going to make. Right, so for 2016, you have a low level of pedestrian stops. And you have concerns about the police slowing down their activity. But looking at the dotted line, what we see is that although the level of pedestrian stops drops off in 2016, over time, vehicular stops start to take the place of pedestrian stops. So the police are increasing dramatically the number of vehicular stops that they're making. You do see a big dip in 2019 to 2020, which we think is associated with the pandemic. Right? So the takeaway here is that policing patterns are changing, and they're changing from pedestrian stops, which have been a subject of a lot of contention in the city of Chicago, to vehicular stops, which are not quite as focused, right? So how does this connect to patterns of gun possession arrests? Well, we took a look. This is the pedestrian stop data because we don't have the vehicular stop. We took a look at when and how stops are accompanied by searches. Under Terry, a stop can be accompanied by a frisk if there's reasonable articulable suspicion respecting the risk that a person presents. And you would think that unless there was a dramatic change in the nature of the population being stopped, the ratio of frisks per capita of stops is not going to change all that much. So what we see here is that between 2019 and 2020, there's a big change in the ratio of stops to frisks. That is, for any given stop, it becomes much more likely that a frisk occurs, right? So it's not entirely clear how to interpret this data. Let me give you another chart which makes the same point. This is the number of frisk pat-downs and searches beyond pat-downs that occur per capita frisk. It's not entirely clear how to interpret this data. Maybe police are stopping people who appear more dangerous and therefore warrant a Terry frisk more frequently. That seems unlikely. What seems more likely is that police, when they engage in stops, are much more likely to be using the stop as a platform for engaging in a frisk with the aim of acquiring or identifying a firearm. Okay, so there's the shift in policing. The shift in policing is aimed at acquiring firearms. This is the last point that I'll make, and then I'll stop. This data breaks down both pedestrian stops and vehicular stops over time by racial group, and it looks at the way that the proportion of people being stopped, whether they are being stopped on the street, on the sidewalk, or whether they're being stopped in a vehicle, what the percentage of people of different races is. Now, it's useful to know in the background here that Chicago is a city which is roughly 1/3 white, 1/3 Hispanic, and 1/3 black. What you see here, in particular, look at the solid black line that shoots up from 2018 to 2020 on both charts, is that there is a dramatic increase in the proportion of stops which are stops of black pedestrians or stops of black motorists. So you have, in response, the way that we would interpret this data is that in response to the BLM, to the pressure imposed by the BLM movement and to the pressure imposed by increasing crime, the Chicago Police Department has turned to a policy of stopping and frisking in order to, as Superintendent Brown said, take guns off the street. And this is a policy that has fallen with increasingly fierce concentration upon largely the black, but also the Hispanic populations in Chicago. And this dynamic of shifting policing patterns is, we would submit, part and parcel. It's of keeping with the historic ways in which the municipal response to gun crime has been bifurcated into a failing regulatory response and a increasingly harsh, increasingly successful, in its own narrowly defined terms, policing response, which only entrenches and embeds the kinds of racial disparities, the forms of racial marginalization that are in large measure to blame for the crisis of violence and for the BLM protests in the first place. Thank you.
Aziz, thank you so much. Professor Rubin, we'll turn it over to you.
Thank you. And thank you to the Harvard Law Review and to the Duke Firearm Law Center for putting on this symposium. It's great to be here. And I'm also happy, usually when we do things in alphabetical order, because my name's Rubin, I go last, so it's nice to be on a panel with a Winkler. Thank you. So in recent years, so my project is looking at the likely consequences of loosening public carry restrictions. And in recent years, most of the scholarly and policy making attention regarding guns in public has been on criminal laws that prohibit carrying handguns without a license and set certain requirements for getting those licenses. But those licensing laws are either falling away because of policy making or court decisions, or they're getting defanged. So over 20 states no longer require a license at all to carry a handgun in public. And most of the remaining 30, plus the District of Columbia, have incredibly lax standards for getting a license to carry a handgun in public. You might have to pass a background check or log a few hours in a shooting range, but the requirements are pretty lax. In the New York State Rifle and Pistol Association v. Bruin, which is the Second Amendment case pending right now before the Supreme Court, it seems likely that the Supreme Court is going to declare unconstitutional stricter policies that require a showing of heightened need in order to get a permit to carry a handgun in public. Now, one view with regard to this trend is that it's the end game, which of course could have some profound consequences for the way that we think about guns in public. Data show that more people carry guns when it's easier to do so. And when licensees engage in crime, the crimes tend to be more serious than for non-licensees. Reva and Joseph have shown other ways that guns in public can affect democratic institutions. And as it relates to private policing or vigilantism, there could be a concern that more civilians will feel empowered or even incentivized to engage in armed vigilantism. But my basic goal is to highlight how licensing is not the end game here, and to highlight some ways that the relationship between criminal law and public carry go far beyond licensing. And I'm focusing in particular on the doctrine and the laws that do intersect with guns in public. There are many intersections, and they provide both incentives to carry guns and disincentives. After Bruin, I suspect that these mechanisms that the criminal law has for intersecting with public carry are going to become coming into focus much more so than they have in past years, where so much of the attention, especially in the Second Amendment literature, has been focused on licensing regimes. And one of the reasons why I think this is going to happen, and this does jive somewhat with the presentation that Aziz just did, is that just like the 2020 BLM protests did not affect policing in the way that we might have expected, I don't think that if licensing regimes fall away after Bruin, policymakers are going to just throw up their hands and say, okay, we're no longer concerned about these externalities. Rather, this will simply divert attention to other mechanisms and other mechanisms in the criminal law that are used to regulate and govern the public carrying of firearms. So my project shines a light on some of these non-licensing intersections between criminal law and public carry that I contend are going to be coming into focus after Bruin. And to be sure, I don't think that these mechanisms solely regulate guns. I think that there are ways that the criminal law can also operate to incentivize gun carry. And in this regard, my short essay for the symposium is not normative so much as it's descriptive and predictive. It's an effort to expand the frame and encourage more attention on the ways that the criminal law intersects with public carry beyond licensing regimes. So in my remaining time, I want to set out two ways that the criminal law intersects with public carry. The first operates to the advantage of gun carriers, and it derives from how the law of self-defense, and in particular the proportionality requirement, can grant greater leeway to gun carriers to use lethal defensive force than non-gun carriers because of the risk of disarmament. And this is something that I call in the essay that he was going for my gun defense, and it featured prominently in the Rittenhouse case. It was raised in the prosecution of the shooters of Ahmaud Arbery, and it also came up in the Zimmerman prosecution for the shooting of Trayvon Martin. The second works to the disadvantage of gun carriers and is known as the deadly weapon doctrine. And what the deadly weapon doctrine does is it permits jurors to infer that a defendant had the requisite mens rea for murder if the defendant used a gun or some other deadly weapon in a homicide. And importantly, for present purposes, that inference of malice applies if a defendant was perpetually armed, the way that a defendant or somebody might be armed habitually under loosened public carry regimes, licensing regimes. But there's an exception, and it doesn't apply if a defendant isn't habitually armed, but rather just arms because of a particularized threat. So I'll start with that he was going for my gun defense by first saying a few words about self-defense law and then using the Rittenhouse case as a demonstration of how this can play out. So it's rudimentary in self-defense law that defensive force is only lawful if necessary and proportionate to a reasonably perceived threat. With respect to that proportionality requirement, penal codes generally differentiate between deadly defensive force and non-deadly defensive force. And all authorities agree that deadly defensive force is permissible if a person reasonably fears a deadly threat or a threat of great bodily injury. In contrast, if the threat's less serious, only non-deadly force can lawfully be used to defend oneself. Since we're here in Boston, I thought I would pull some Boston history on this point. In the famous 1806 prosecution of Thomas Selfridge for the killing of Charles Austin, which arose here in Boston, Judge Thatcher, instructed the jury that, quote, he doubted whether self-defense could in any case be set up where the killing happened in consequence of an assault only, unless the assault be made with a weapon, which if used at all would probably produce death. And there are plenty more recent cases that say that lethal defensive force is not proportionate to, say, a punch in the jaw or some other type of simple assault. So how does he was going for the gun defense come in here? So let's take a look at the Rittenhouse case. In that case, Rittenhouse concedes the elements for murder. He concedes that he intentionally used lethal defensive force that caused the death of another person, or actually 3 people. But then he asserts the defense of self-defense, and he says that his use of lethal defensive force was justified. His case, because it involved the use of lethal or deadly defensive force, meant that he had to reasonably fear not just an assault, but an assault that would rise to the level of a threat of death or serious bodily injury. So what, in his view, gave rise to that threat of death or serious bodily injury? One of the men that he shot, Joseph Rosenbaum, was chasing after Rittenhouse and lunged at him. But Rittenhouse correctly believed that Rosenbaum was unarmed. And this is where Rittenhouse's decision to carry a gun comes in, because he argued that he feared that if Rosenbaum were to tackle him, if they were to wrestle, Rosenbaum would take his gun and turn it and use it against Rittenhouse. That, in his telling during the trial, is what, in essence, elevated this threat from one of potentially, arguably, non-lethal force to one of deadly violence. And it's worth noting, as I mentioned, that being disarmed is not it's not an unreasonable fear for somebody who decides to carry a gun. Avoiding disarmament is a basic component of gun carry training. In another case where he was going for my gun defense comes up, the murder trial of Ahmaud Arbery's killers, the defense attorney recounted one of the defendant's Coast Guard training. He said, quote, "Never lose your weapon, and that's why he shoots," end quote. And the same argument comes up in the Zimmerman case, where Zimmerman's attorney says that at the time he shot Trayvon Martin, Zimmerman feared that Trayvon Martin was reaching for Zimmerman's gun. So the question arises, does the criminal law have to operate this way? Should it? How does the availability of this "he was going for my gun" defense or argument affect the thinking of would-be vigilantes? I'm going to return to those questions in brief in conclusion, but first I want to raise another example of how the criminal law intersects with gun carry beyond licensing, which is known as the deadly weapon doctrine. If the "he was going for my gun" defense works to the advantage of a gun carrier in lethal self-defense cases, the deadly weapon doctrine disadvantages gun carriers. Under this doctrine, if the gun is used in a homicide, the jury receives an instruction that it can infer the requisite mens rea for murder as opposed to some lesser form of homicide by virtue of the use of the gun. The basic logic here is that a deadly weapon is, by definition and by design, likely to cause death when used as it was designed. And so the use of such a weapon can rationally be used to infer the deadliness of a defendant's purpose. This doctrine existed in one form or another and has existed for centuries. An author in a 1962 Harvard Law Review comment noted that few doctrines of the common law of crimes are as frequently encountered as this deadly weapon doctrine. And significantly, why a person arms with a gun is relevant to the decision whether a judge is going to charge the jury on this deadly weapon inference. In particular, when a defendant arms only in response to a particularized threat. In other words, the defendant is not carrying a firearm habitually, but rather thinks that there is a particularized threat that could be carried out, and that is why the defendant decides to carry a gun. Judges have withheld the deadly weapon instruction. On the other hand, judges have said that someone who arms long before any given threat arises can still be subject to this deadly weapon inference at their trial. Many of the places that have loosened public carry restrictions still adhere to this criminal law doctrine, which in turn cuts against or works against the perpetual gun carrier. Now, these two examples of ways the criminal law intersects with public carry only scratch the surface, and my goal, again, is simply to shine a light on a broader patchwork of criminal law doctrines and mechanisms that relate to public carry, and they've largely been overlooked in the discussion about licensing. So, for example, the criminal law grades crimes differently depending on whether a gun was carried, and it sentences crimes differently when guns are involved. On the other hand, I think it's no coincidence that the National Rifle Association and gun rights advocates pushing for the removal of licensing, including in the current Supreme Court case, are also the chief proponents of other changes to the criminal law, such as stand your ground policies and a trend of granting prosecutorial immunity to those who say they use their weapon in self-defense, which allows a defendant to avoid a prosecution and trial altogether if they succeed at a pretrial hearing. And that's the subject of another law review article that I've written. And the fact that the law is changing is a reflection of the fact that legislators can adopt or reject such mechanisms to achieve optimal outcomes in their view. So, for example, related to the "he was going for my gun" defense, you can imagine the criminal law being adjusted, such as by imposing a burden on a defendant who's raising this "he was going for my gun" argument to prove by a preponderance of the evidence or some other standard that his fear of disarmament was genuine and reasonable. And jurisdictions can choose whether or not to adopt the deadly weapon inference or not. Other proposals are starting to trickle in. So Professor Cynthia Lee, in a fantastic forthcoming article, argues for adjusting the initial aggressor doctrine to account for increased gun carry. To oversimplify, an initial aggressor generally loses the benefit of the law of self-defense. But judges frequently don't charge or don't instruct the jury on the initial aggressor doctrine. And her proposal, among other things, is to require judges to give an initial aggressor instruction whenever a defendant claiming self-defense brought a firearm outside the home and displayed it or brandished it at another person. So to wrap up, I don't mean in this project to minimize at all the significance of removing strict licensing if that's what ends up happening in the Bruin case. Licensing is a way to prevent unnecessary gun carry on the front end. But I also don't think that licensing is going to be the end game here, the end of the story. Rather, I think it's time to consider other ways that the law and the criminal law gets deployed to address the externalities of public carry. And that, in turn, is going to raise a whole new set of questions and concerns about the propriety of those mechanisms and the efficacy of those measures that I think is going to garner a lot more attention in the coming years.
Thank you so much. Just to add to your list of potential cross-fertilization implications of the change in public carry and criminal law, not so much substantive criminal law, but criminal procedure, and I'm teaching criminal procedure this semester, and we were just talking about this the other day. So the term armed and dangerous is a trigger for an enormous amount of police authority. So if police reasonably perceive me to be armed or dangerous, they can shoot at me, they can frisk me, they can take measures that they would otherwise not be authorized to take. And one of the things that we think about in criminal procedure is what's going to happen to that confluence. So armed, presumably, is an objective, either you're armed or you're not, but dangerous is a judgment. And the sort of knee-jerk association of those two concepts in criminal procedure, I think, is subject for rethinking, just as you suggest that some of these doctrines might be subject as well.
I totally agree, and I think there's a question under Fourth Amendment doctrine, like, do you have reasonable cause to suspect a crime is afoot if somebody's just carrying a gun, for instance? If there's a right to do so, maybe you don't have the Fourth Amendment authority to do that stop in the beginning, to begin with. And if somebody does have a gun, can you suspect that they're dangerous so as to disarm them? So this goes completely to what you're saying, and there has been some litigation on this, but it's only going to become more prominent and more interesting in the coming years. I
tell my students, this is your generation's problem. You are going to be litigating this for years. Professor Winkler.
Okay, great. Well, thanks to everyone for having me, and for the center and for the law school and for the students for organizing everything. It's a real pleasure to be here. So I want to talk about how we should think about the history of racist gun laws in America and what implications that history has for Second Amendment doctrine and gun policy more generally. And I want to make 3 points. The first is that the history of racist gun laws will greatly complicate and perhaps even fatally undermine the turn to history and tradition as a test to define the scope and boundaries of the Second Amendment. 2, I want to argue that the history of racist gun laws gives us cause to be more attentive to the commonplace racially disproportionate impacts of many gun measures, gun violence measures, and gun laws. And then 3rd, I want to say that the history of racist gun laws provides possibly a reason for thinking about integrating equality and equal protection concerns into Second Amendment doctrine. And here I'm going to take a little bit of a disagreement with Joseph and Riva's paper that's coming later that suggests not incorporating equality concerns into Second Amendment doctrine. So first, that the history of racist gun laws complicates and perhaps even fatally undermines the turn to history and tradition. It does seem one of the things that will be determined in Bruin is what is the new test for Second Amendment cases and determine the constitutionality of gun control. And one likely option there that seems most likely to win is a test that focuses on text, history, and tradition. Brett Kavanaugh has been a big proponent of this, as have some other justices. And the way this test works is the courts will look to past legislation to see how gun rights have been regulated in the past. And if we find some a history and tradition of regulating guns in a particular way, well, then that is presumptively constitutional. And if we look to history and we don't find any antecedents, then that law is more likely to face a skeptical scrutiny from the courts. And the value of the text, history, and tradition approach, according to those who advocate it, such as Kavanaugh in his Heller II dissent, is that that turning to history is a fact-based way of figuring out what the scope of the Second Amendment is. You're looking at past illustrations of efforts to balance Second Amendment rights with gun policy, and that by looking to text, history, and tradition, we are going to minimize the discretion of the judge to impose the judge's own values on the Second Amendment and cabin that judicial discretion. But of course, when we look back at historical antecedents in America, what you see is that there's actually a lot of history of racist gun laws. That the founders who wrote the Second Amendment had racist gun laws prohibiting blacks, whether slaved or free, from possessing or carrying firearms. We know about the black codes after the Civil War, and some of the briefs in the Bruin case argued that the Sullivan Law, adopted in New York in 1911, was itself a product of at least some measure of xenophobia against Southern European immigrants and others. And so how should we think about this racist history of gun laws when doing a history and tradition analysis? Well, one possibility is that a judge could say, well, any law in the past that was tainted by racism is totally irrelevant to a history and tradition analysis, that we won't even consider that law as an observation that's worthy of consideration. And I think there are two problems with this approach. One, it's going to lead to an inaccurate assessment of what the scope of the Second Amendment is. If the way of figuring out the scope of the Second Amendment is looking backwards and seeing what the data provide, well, ignoring a large number of the observations because of the taint of racism, I think will lead judges to have an inaccurate sense of what the scope of the Second Amendment is. In many cases, we can imagine that legislatures used valid public safety regulatory authority, but in bad ways, right, to do racist things, right? Crim law obviously was used for racist purposes. Voting laws were used for racist purposes. Marriage laws, zoning laws, property laws, etc. We don't say today that government doesn't have the right, have any ability to regulate property or to regulate voting in any way. We recognize that authority existed, but it was misused because race was encouraged. So we'd end up with an inaccurate sense of what the scope of the Second Amendment is. There's also the second problem of how much racism is too much. A judge concerned about displacing all of this history of racist gun laws when doing this text, history, and tradition analysis will then have to be confronted with, well, like how much racism is too much? So take that Sullivan Law in New York. There were valid public policy concerns and public safety concerns that helped motivate that law. It wasn't just xenophobia. How do we think about that? Which of these concerns is one disqualifying? Does the other one make it that the law is constitutionally permissible? And what do we do about laws that were passed in some states if we assume that the Sullivan Law was xenophobic or racist in its orientation or motives? What do we do about the fact that the same type of law, discretionary permitting for concealed carry, was adopted in like 30 states at that time, including states like Montana and South Dakota, where there's no reason to believe that that was motivated by xenophobia or the same kinds of racist concerns that might have motivated New York. So is that kind of law constitutionally permissible because it was adopted in places like Montana and South Dakota without racism? Or is it constitutionally infirm because xenophobia played at least some part of it? A second possibility is that judges could say, well, we're going to consider racist gun laws, but we're going to frame them at a higher level of generality. And so we see this already in the gun rights scholarship. Don Cates, for instance, has argued that bans on felons possessing firearms are justified by analogy to founding era laws that prohibited black people from possessing firearms or Native Americans from possessing firearms. And the argument that he makes is that those laws reflected government power at a higher level of generality. That is to say, government had the power under the Second Amendment to restrict possession of firearms by unvirtuous people. And the framers misapplied that idea and applied it to people of color when that wasn't really a sign of lack of virtue, but we could use that today to prohibit felons from possessing firearms. And the problem with this approach is that, of course, it's going to invite the exact same judicial discretion and potential judges imposing their own views on the Constitution that the text, history, and tradition approach is supposed to avoid. After all, it's judges who are going to decide that lack of virtue is the reigning category or dangerousness is the reigning category, when those were not the terms or categories directly used and justified in the founding era or over the course of American history. As Judge Easterbrook argued 4 decades ago, that movements and levels of constitutional generality may be used to justify pretty much any outcome at all. So if we use racist gun laws and look at a higher level of generality, we've then just sort of undermined the whole purpose of the text, history, and tradition approach. And so I believe that the history of racist gun laws seriously undermines and perhaps even not just complicates, but fatally undermines this history and tradition analysis. So second point about history of racist gun laws encourages us to pay more attention to the racially disproportionate impact of gun laws today. We know that gun laws often disproportionately impact communities of color. Approximately 70% of all defendants charged with federal firearms offenses are people of color. That's compared to about 40% of the population, so widely disproportionate impact. Popular laws that even in the gun safety community are considered untouchable, things like bans on felons possessing firearms, of course, also have a very disproportionate racial impact because of patterns of over-policing in some communities, under-policing in other communities. More than it's estimated that more than approximately 1 in 3 black men in America have a felony conviction on their record. That means 1 in 3 black men in America do not have the Second Amendment right to keep and bear arms. These problems persist even in reforms, popular reforms that might not be thought of by reformers in racial terms. Take a popular law at the top of the gun safety reform movement agenda, bans on high-capacity magazines. So New Jersey's adopted this, California's adopted this. But we can expect bans on high-capacity magazines to likely have a racially disproportionate impact. So what's happened in states that have banned high-capacity magazines is widespread non-compliance, right? We don't see any real effort to give up these high-capacity magazines. Gun owners are not giving them back to the police. We just don't see any evidence that these laws are actually reducing the number of high-capacity magazines that are in the possession of citizens. So who gets arrested for having a high-capacity magazine? Well, again, it's those who are the victims of over-policing, who are more likely to be stopped and searched on the streets or stopped and searched in their vehicles or have their homes searched. Again, likely to see overrepresentation in minority communities. I thought that the public defender's brief in NYSERPA was really a powerful, passionate testimony to the ways in which it's important for people who have progressive values to think about how gun laws are impacting people's lives, and especially the lives of people of color, in a way that's racially disproportionate. And so I think that it's incumbent upon us to think about minimizing those racially disproportionate impacts from gun policy and gun violence prevention efforts. One way to do this, for example, is to move away from criminalization and more towards community intervention programs, things like Operation Ceasefire that have proven to be pretty successful. And third, as a final point about the implications of the history of racist gun laws, I want to suggest that equal protection concerns can and perhaps should shape Second Amendment doctrine. We have seen that justices have been more sensitive to race and racial discrimination in Second Amendment cases than in other areas of law. Justice Alito, for instance, who seems to never see racism and discounts the possibility of racism in voting laws, in immigration laws, and a whole bunch of other areas of laws, is quick to notice racism in gun laws. And his opinion in McDonald talks a lot about how racialized efforts to disarm Southern blacks helped inspire the 14th Amendment, et cetera. In the NYSERPA oral argument, Alito asked about the potentially xenophobic and racist motives behind New York's discretionary permitting law. Now, I'm not so Pollyannish to think that these will lead to Justice Alito seeing race in other areas of law where he should see it. But I think it's overall a net benefit when we have justices, even on the conservative side, that are looking at facially neutral laws, understanding that they have a racially disproportionate impact and maybe a racial history, and being sensitive to those racial concerns. You might say at least he's talking about it somewhere, and I do think that talking about it there can help breed understanding of how race works in other areas as well. I agree with Riva and Joseph that we shouldn't expect too much out of the court's equality if the court incorporates equality into Second Amendment concerns. But I do think it might impact the Second Amendment in some positive ways. And it may just be about the best of some bad potential outcomes. So take one law that we might see come under constitutional scrutiny in coming years. The court might say, as Amy Barrett did when she was a lower court judge, that the lifetime ban on felons possessing firearms is unconstitutional. And there's two ways you could get at that. One, you could say that the law is just arbitrary, that it's irrational to prohibit 70-year-old people who have a 50-year-old conviction from possessing firearms. There's not really much data to suggest that those people are dangerous with firearms, and thus the law is irrational. Or alternatively, we could imagine that opinion being written with real sensitivity to how the lifetime felon possession ban is affecting communities of color and has robbed 1 in 3 black men of a right that the Supreme Court says should be equally enjoyed by everyone. I think that latter option's a better of those two options in that it helps set a precedent for how we think about race and where we see race in the law that can be used and can have an effect in other jurisprudences, other doctrines in a positive manner. And so a Second Amendment doctrine is really just emerging, but I can imagine a world in which it does include an equal protection component that is overall beneficial to how we think about the law. And so those are my 3 points, and turn it back over to our distinguished moderator.
Thank you. Let me just get a sense of folks who think they might ask a question. I want to give, so let's do this. Let's take a couple of questions, and then I want to turn back to the panel for a moment and just give the panelists a moment to respond to each other. So let's take a couple of questions here, and then Aziz, and then Eric, and then Adam, in case you wanted to riff off of anything that our colleagues have said to keep the dialogue going. But Riva, please. Oh, I saw your hand. Oh. No, I want to give them a chance to think since I just sprang it on them.
Well, they're all fabulous papers, but since Adam invoked ours, I'll sort of come in there, although every one of them is great, so I'll just be brief. So when Joseph and I wrote in Northwestern last year, we were making a huge point of defining public safety not just as a matter of protecting bodily safety, but protecting security in such a way as to enable people to be able to exercise their liberties in the public sphere. And that once understood in those terms, it needs to be protected in such a way as to enable all persons, regardless of point of view, of colors, of every kind, to be able equally to be able to have the security to inhabit public spheres. And so it has at its core a commitment to racial equality. So that was the point of the Northwestern paper. But that assumes that's the government regulatory project, not as it's presently practiced, but in its ideal form. It's very far away from its present practice. So we went from that starting point into this paper. And one of the reasons why we went into this paper with the anguish that we did, engaging...
Start your question over again, I guess. Right.
One of the reasons why we went into this paper, engaging the public defender's brief with the anguish we did, is because of the ginormous gap between the real and the ideal, and the sort of distance between public safety as it's embodied in our cities and the way that we were invoking its ideal practice. So then the question becomes, what institutions, plural, in our constitutional order would vindicate it? We have a habit of looking to our federal courts. We're taught to look to our federal courts to vindicate racial justice, but as we'll say later, not this one, And so while it's true, and this is what I wanted to respond and then I'll hand off to other people, while it's true that Justice Thomas will talk about racial justice in these matters, in McDonald or in the RJ cases or whatever, it's always to a certain direction and not to another. And when it comes to equal protection, they'll take the Harvard case or affirmative action case and watch what happens in the voting rights space. And so there's a difference between, this is why I was talking about constitutional memory, there's a difference between the stories about race they invoke and the law that they're making and who's being empowered and protected by what they're doing. And so, and this is what I was saying earlier and I'll stop, all of the stories about white supremacy or racial, the disempowerment of people of color in the Second Amendment cases work to justify gun rights. They don't play a role in authorizing the state to regulate guns. And so the question is, do we need other narratives that come to bear on the state's authority to regulate guns to other ends? And I agree the ends should be defined in a way that recognize the imperative of a public sphere that protects for all to inhabit.
Thank you.
Yeah, let me just say one thing that we can go till 12:05 for this panel, and then I have a question from the online.
Well, let's hold off on that, please. Adam, did you want to respond for a moment? And then I think I saw Guy has a question, and then I'm going to turn it over back to the panel for a little bit.
Yeah, I'll just respond shortly to saying that it's fair criticism to recognize that those arguments are only used one way by these courts at this moment. But I do think that these cases do get read by law students. They do help create a constitutional culture for how we think about particular kinds of issues. And I don't think they're easily cabined as only arguments that will serve conservative ends and gun rights ends over time. With these justices, I don't have any particular expectation, right? But thinking about equal protection being integrated in the Second Amendment doctrine in the long run, I think may be more beneficial and may have a positive salutary effects as well.
The only thing I want to say is that these justices are cutting off the authority of other constitutional actors to realize constitutional values in a way that may be more minority community empowering. That's the only concern that I have. But it's true that these stories, they need to be told.
Can we give the mic to Guy? Thanks.
Actually, my question follows on that conversation, and in some respects it's directed toward Aziz and Adam, but Eric as well, which is, so on the one hand, Aziz tells us that, look, the political process, right, you have a black mayor, you have a city in which there's a large number of black people. The political process is also leading to the types of equality worries, racial equality worries in the gun context that we've worried about historically, right? So you can talk about tradition and history, but you have modern instantiations, and the worry about political empowerment does not do the work that we think that's doing. On the other hand, we're also worried about the court and the probability that, yes, the courts might use race, but not in a way that furthers racial equality. And so the question is, okay, well, what is the solution? Right? How should we think about these issues, given that the avenues that we've traditionally employed, political process, courts, community, and the worries about under-enforcement and over-enforcement that Sasha started to frame the panel with, all of it just seems to, every avenue seems to lead to racial inequality. So I'm curious as to how you all address these issues, especially in the context of violence, right? So it's one thing to think about it in the context of voting, which is, we're all banging our heads to try to figure it out, but in the context of violence.
Thank you so that teed it up beautifully. So let's do this, Aziz, and then Eric, and then Adam. I'll give you a chance to respond to Guy's question, but also anything else you want to add. Aziz, can you hear us okay?
Yeah, I can hear you.
Great.
Let me respond to Guy's question, and then let me take up, Alexandra, your invitation to say something about the other panelists. And I think I want to say something about Adam's really interesting presentation, just because Adam's work is, I think, closer to what I know a little bit about than Eric's, which is to say more about my limitations than the content of Eric or Adam's papers. So in response to Guy, I would say the following. One of the reasons that Professor Vargas and I embarked on this project, and we're looking not just at Chicago, but also at a number of other cities that have had active BLM or other social movement mobilizations, is the thought that is advanced in the legal literature by a range of scholars associated with, I guess, what could be called the law of social movement or law for social movement school these days, that it is that there is the possibility of, or the most effective channel for progressive social change today is through the instantiation of popular power in institutions or through pathways that are relatively localized and decentralized rather than legalistic and centralized, right? That I think is a claim that has been made in the pages of the Harvard Law Review, it's been made in the pages of the Yale Law Review, it's been made in the pages of the Stanford Law Review, right? And it's a purported answer to the question that Guy has put on the table. And the thrust of the project that Robert and I are engaged in is to ask whether that is empirically true, right? And it is a predicate step in prescription to describe the landscape of institutional realities or institutional, the play of institutional forces that determine the possibility of reform. And to assume at the threshold, as I think the law and social movement scholarship does, that there necessarily must exist an efficacious pathway is empirically and methodologically utterly unjustified. And in part what this paper and what the work that we want to do following it is going to try and excavate is why the kind of social movement theory developed by people like Doug McAdam in the sociology literature just is not replicated in the same ways, or just cannot be replicated in the same ways today. And I think of myself, therefore, as answering your question, Guy, but I think of it as coming to it in a kind of Gramscian spirit of not assuming that my optimism of the spirit is going to translate into optimism of the intellect. Okay, that's the first question. So I wanted to say something about Adam's paper quickly, and it's this. So Adam's comments and the proposal that he offers is organized around the idea of discrimination, and the word, Adam, that you kept using was racism, which I take to be indexing the ideas of animus or discriminatory intent. One concern I would have with that framing, and it comes from, I think, a non-doctrinal perspective, is, and this echoes something that Guy said, is that my observation Robert and my observation in the paper that I just presented is that we have, Chicago's second black mayor, first gay black woman mayor, essentially moving through the same steps that the Daley administrations and the Chicago machine worked through 2 decades, 4 decades ago, right? And the identity and the progressive credentials of that mayor, such as they were or are, just doesn't matter. What matters is the structural forces that determine and that fix her in particular tracks. And to think about the problem of the spillover effects or harms that have racial dimensions in terms of discriminatory intent, I think doesn't grapple with the nature of the problem here. I think that there's further evidence for that in David Huro's brilliant paper that was published in Daedalus earlier this year that looks at the way that gun regulation generates real human costs in particularly minority communities in urban cores. And I'll give you one example from Huro's paper. Huro says, look, the reason why we see much higher levels of mortality from crime occurring in those minority communities is that there's a point in time at which gun makers increase the caliber stock of firearms that they're selling, right? The modal and the mean caliber stock dramatically increases. And the reason for that increase, which is a change in the modality of production by gun makers, is there's increased demand for firearms that have stopping power because of the changes in concealed carry law. So the dynamic or the link between the landscape of gun laws and the way in which the material harm is wrought by guns on black and brown bodies is not through a channel that is defined by intent or animus, and therefore a doctrinal framework that tries to grapple with the connections between race and guns, which assumes that animus is that channel, is necessarily going to fall short.
Thank you. So let's do this. Adam, I'll give you a second to think about what Aziz has put on the table. Eric, and then Adam, we'll let you close us out because I think we only have about 5 more minutes left.
So, Guy, your question was excellent, and you ask about solutions, and I don't have solutions to the question that you asked. I think that I do have a comment though, which is that a lot of the concern is about the way that the criminal law focuses, and policing focuses on getting guns off the streets. And in Aziz's presentation, Aziz talked about how guns have this rhetorical force, and gun talk plays such a large role and has played such a large role in Chicago's treatment of this issue. And Guy, you mentioned that there are this is a modern manifestation of something that has happened historically, and I think that, I think that point is really important for understanding how deeply rooted this is in our criminal law, and I think that it's actually even deeper rooted than a lot of people might think. If you go all the way back to the 1800s or back to the beginning of Anglo-American criminal law, it's always been concerned not only about violence but about the instruments of violence. There's always been criminal regulation of weapons. It hasn't always been guns, but there was a focus on knives in the 1800s. Texas, for instance, punished people more severely if they committed a homicide with a knife in the 1800s than any other weapon, because that was the weapon that was viewed as most problematic. It wasn't guns. And so the fact that this is manifesting in this way right now is, I think it's important to understand just how deep-seated, and I don't know what the solution is to this, but there is something that is almost innate in terms of how we criminally regulate society and how we police society, between a focus on the instrumentalities of violence. It's always been that way, and it hasn't, and I think that it needs to change, but changing it and trying to figure out a solution, especially in light of what we know now about disparate impact, is a massive project, obviously, and decriminalizing weaponry, I have a hard time believing that that's going to be real anytime soon, just because of how inherent that is and always has been in our criminal law.
Yeah, no, great, and I should say, Aziz, I agree with the points that you were making, and in the piece that I wrote, I actually make the specific point that we shouldn't be seeking to find discriminatory intent. Like, if that's not the component of equal protection principles we should incorporate into the Second Amendment, for good reason, some of the reasons that you talk about, that you mentioned. And that's why I really tried to emphasize in my talk the need to start focusing on racially disproportionate impacts, not discriminatory intent. My argument was certainly not, let's bring Washington v. Davis into the Second Amendment. It's rather, maybe let's imagine a Second Amendment doctrine where racially disproportionate impact is something that is troublesome to courts and troublesome, perhaps even more importantly, to reformers and advocates in this space. That I think part of this is a call for those who favor more restricted gun rights and more gun safety laws to be racially aware to the disproportionate impact that some of these reforms can have, and instead to try to focus and emphasize on reforms that will minimize or avoid that racially disproportionate impact. That's part of our obligation as people who are seeking to reduce gun violence, is also to make sure we do so in ways that don't have that disparate impact, regardless of whether there's discriminatory intent.
Well, unfortunately, we're out of time. I know there were a couple more questions. I hope you'll feel free to come up and ask the panelists during the lunch period. Thank you all very much.